Assalamualaikum warahmatullahi wabarakatuh. My name is HARITH bin HILMI. My matric number is 2891. So we are from Group 6. I want to discuss about Dato' Haji Nik Mahmud versus Bank Islam Malaysia BERHAD in concept of Bai Bitaman Ajal or BBA. The issue we want to discuss is the transfer of ownership on land under Islamic banking concept of BBA is null and void. So the background of the issue is the plaintiff, that is Dato' Haji Nik Mahmud, signed to contract with defendant, that is Bank Islam Malaysia BERHAD, on May 6, 1984, namely the agreement to purchase property and the deal to sell property. The defendant paid cash for the property to arrangement first at a price of RM520,000. After that, the property was resold to plaintiff under a new contract for RM629,000 with a delay payment. On the same day, May 6, 1984, both a purchase agreement and sale agreement for a property were signed. Next, the property had two charges put in place in favor of the defendant on May 8, 1984 by the attorney for the plaintiff. The pawn document is listed as the guarantee at the land office for an RM629,000 loan issued using the Islamic banking system known as BBA. Plaintiff requests an order that the charge date May 8, 1984 be dismissed on October 5, 1994 through the filing of beginner motion number 2526, 1994. Both the contract to sell the property and the contract to buy it were ruled to be invalid, ineffectual and void. Dispute between the plaintiff and defendant about a number of legal matters include the situation summary is as follows. Number 1. Whether there is genuine business on the land or attempt to do so in accordance with Section 12, Subsection 1 of the Kelantan Malay Reserve Land Enactment 1930. Number 2. Is the implementation of the agreement unconstitutional because it contravenes Section 7 and 12 of the Kelantan Malay Reserve Land 1930 Act. Number 3. Whether the registration was obtained using an incomplete document or whether it was invalid as defined by S. 340 of the National Land Code of 1965. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Safwan binti Saupi, entry number 288887. Alright, okay, next we will look at the law case related to the Dato' Haji Nik Mahmud versus the Bank Islam Malaysia BERHAD. Okay, the law related to the case includes Section 7I, restriction on transfer or interest, and enactment 12I dealing contrary to the end, and the Section 320 bracket 2 of the National Land Code 1965 Clause B. Based on the Section 7I, it has been clarified that no right or interest in any Malay reserve land and no right or interest in such land acquired pursuant to Section 30A by any person who is not Malay can be transferred or to a west in a right to any non-Malay provided that the reserve land lease shall be valid to the extent specific in subsection 2 and 4 below, except as provided in this enactment. According to Section 12 on the enactment, it has been explained that they opposite to the end. All dealing or disposals whatsoever and all attempt to deal and dispose of a reserve land contrary to the provision of this enactment are new and void. The appellant argued that the execution of the property purchase agreement PPA and the property sale agreement PSA violate Section 7 and 12 of the enactment, which prohibit the transfer of any right or interest of Malay in reserve property. As the bank is not Malay or Kelantan, it has claimed that the land cannot be transferred to the bank under the PPA. Okay, the framing of the charge by appellant has not effect and should be rejected as its existence depends on the PPA. Okay, next we will look at the law section 340 subsection 2 of the National Land Code 1965 clause B, which state that circumstances in which land ownership right for person listed in a legislation document may be denied. In the clause of section B, if the land title transfer to be from the landee, the registered land title can be denied. For example, misusing the name or signature of the registered owner to sell or transfer land ownership to a third party without the knowledge of the real owner. In the case the bank preserved an agreement under the section 340 of the National Land Code NLC that there is untrustworthiness under the said section to make a transfer of ownership right or interest of land within the meaning of section 7 of an enactment. The transfer must be done using the properly registered document. A lawyer argued that the appellant could identify which member or the exception and unreliability was evoked for the appellant to deny the validity of the charge. The mortgage document has been registered in the manner outlined in the code, as such registration does not conflict with the enactment, and nothing in law or fact can negate the impossibility of the pledge as provided by the section 340 of the code. Okay, next we will look at the case related to Dato' Haji MAHMUD case and Islamic Bank. Among the related case in the case between CMB Islamic Bank Berhad and versus LCL Corporation Berhad and owners, and also the Bank Kerjasama Malaysia Berhad, Bank Rakyat Kerjasama Malaysia Berhad, and versus MC Corporation Siram Berhad. Okay, let's look at the case in between CMB Islamic Bank Berhad versus LLC Corporation Berhad and owners. This case involved an Islamic banking business where the plaintiff seeks summary judgment against the defendant under the Rule 40 of the High Court Rule 1980 with the amount of approximately RM54,442, RM774 and 8 cents owed by the term financing facility granted to the first defender under the concept of Bintama Ajil BBA facilities. In his application, the plaintiff asked for tadwid, or we call that a comparison and expenses. The second defendant, who is the head of the main respondent, which is the first defendant, provided security to the office and prepared a memorandum of security deposit MOD, and including an offer for the agreed party. The defendant claimed that no money was disbursed under the BBA facility, and the BBA facility was a flow to cover up the schedule of payment under the first facility because the first facility has not been terminated, and the same resources has been used in the second and the third BBA transaction. As a result, the defendant contend that the BBA facility is new and void. This cause it is appear conflicts in jurisdiction also exists between Islamic finance institution and civil law. The validity of Islamic financial transaction has been questioned in the civil court on the ground of violation of the other civil law due to wrong comparison and correlation. We may see this the case of CIMB Islamic Berhad and LSC Corporation Berhad with an honest, where one of the issue agreed to be addressed was whether the BBA transaction convened section 67 and 67A of the Company Act 1965 bracket Act 125 and was therefore invalid and enforceable. Okay, next in the case between the Bank Kerjasama Malaysia Berhad and MC Corporation Siram Berhad, in this case there is an issue the validity and enforceability of BBA contract has been disputed in various situations. In this case, the appellant or bank provided an 20 million credit facility to the respondent under the BBA or called by Bintama Ajil Islamic banking concept. The respondent violated the agreement on loan installment payment. Therefore, the appellant submit a Form 60D notice under National Land Code and seek against the respondents. As the respondent did not comply with the notice, the appellant sought an order compelling the sale of the security pledge under the money lending agreement. Alright, and appeal against the decision to sell the construction period in the second agreement involved the collateral of piece of land for repayment of the purchase price was denied by the High Court. The court is appeal reverse the decision of the High Court and allow the appeal. Alright, it is important to note in this case that it has been emphasized that when the Islamic finance institution is brought before the court on a matter of validity, alright, it does not necessarily mean that the case is brought solely and determine whether the contract is valid according to Islamic principle. This case also show the appropriate legislation in this situation is no different from that used in conventional banking. The second agreement need to be examined based on the validity in the National Malaysia Land Code, and we can see the same case structure as Dato' HAJI MAHMUD with the Islamic Bank, that the validity of the contract is an important thing to see that it is guided by the right standard.
Hi and Assalamualaikum, my name is BINTI IDRIS, my metric number is 28870. I will continue the presentation with the possible solution for the case between Dato' HAJI MAHMUD bin Daud and Bank Islam Malaysia BERHAD. Actually, there are variety potential solutions that could be considered on this case. One of the best solution that I can say is negotiation from both parties. This is because in this case, plaintiff mentioned that the charge PPA and PSA are null and void because of the amount that being stated by the bank, which is 629,200. The plaintiff also mentioned that the bank should return all his title free from any burden. What I can clarify here is the amount that being charged is more than his capability. The negotiation could be the time frame since the amount of charge are fixed and cannot be changed for all the customer. Next possible solution that I can say is assign a mediation in charge to help facilitate communication between both parties. This is because the plaintiff mentioned that the bank put charge, usury or riba on the transaction, where they holding a PPA and PSA are clearly defeat the intention and purpose of Kelantan Malay Reservation Enactment 1930 and the National Land Code 1965. The mediation should play a role of natural third party in this case and explain the detail how the section 7 and 12 of the enactment are being compiled, because there is no proof and evidence that shows that the bank has intention to take the ownership of the plaintiff, and the charge on the document are on the charge registered chargee. Moreover, PPA and PSA is only the tool and instrument that has been used to legitimate the current practice of BBA in Malaysia. I come with another solution, which is underwriting due to all promises and agreement of both parties. This is because to ensure that every single thing that happened in the transaction has evidence in the future. This also ensure that the both parties retain their independence and the litigants are able to have their cases heard by the neutral arbiter in case and not binding the court only. Ultimately, the best way to address and concern raised in this case is through a careful and considerate process of consultation. Both parties should be aware of the agreement that they wanted to sign to prevent any suppression happening. This process also can involve the AC and arbitration to ensure that the contracts rely on the Shariah and are not only defending one side. By working together, it is possible to find a solution that can make both parties satisfied and feel fair, and surely the agreements are in line with the principles of Shariah law. That we can make the case between Dato' HAJI MAHMUD bin Daud and Bank Islam Malaysia BERHAD are on 1984. But in early 1980s, Malaysia don't have any comprehensive legal framework to address any problems that related to Islamic banking sector. In that time, Malaysia also faced unqualified and incompetent judge to decide cases that involve Shariah contracts to the limited knowledge based on Shariah and Muamalat economics. However, Malaysian legal framework is expanding from time to time regarding the implementation of national financial regulation. The validity of BBA contracts under the Islamic Bank Act of 1983 and the Banking and Financial Institution Act of 1989 which both are repealed by the Islamic Financial Service Act of 2013 and Financial Service Act of 2013. Is a legal issue that arises in numerous lawsuit cases in addition to this one. Due to the expanding of knowledge and better legal framework, the court began to show its concern in critically examining the Shariah contract that happened. In terms of judging the issue that related to the Shariah contract, the court supposedly not to have a base common law, but have to learn and have a full of knowledge that are based on Shariah also. This is because to ensure that the public can put the trust and bravely in handling the issue to the court. In signing a project or agreement, all parties should be transparent and since with all the information that is related. This is because Bank Islam Malaysia BERHAD (BIMB) was the first Islamic bank that being established in Malaysia. The public should not have any doubt or problem to be invested in the bank just because of the issue of Shariah law in the contract that the bank handled. I think that's all from our group. If you have any question, you can proceed after the presentation, and thank you.